Confidentiality protects survivors from disclosure of communications between professionals and their clients or patients to any third party in any context. Privilege, on the other hand, is a legal doctrine that prevents professionals from being compelled to reveal communications between the professional and the client or patient in the context of a court hearing or a deposition. So there is some overlap between the protections of confidentiality and privilege. While all privileged information is confidential, not all confidential information is privileged. And what this means is that professionals who are covered by confidentiality have an ethical duty to maintain the confidentiality of private client information and communications. Some of those professionals, but not all, are also protected by privilege, meaning that they cannot be forced by a court to disclose that information or those communications. However, some professionals who are required to maintain the confidentiality of client information, such as medical providers and legal advocates, may be compelled to provide that information to the court in a hearing or a deposition despite the confidentiality rule. So confidentiality and privilege each cover different types of professionals, though, as I said, there is some overlap. Confidentiality protections apply to the clients or patients of medical providers, mental health providers, legal advocates, attorneys, and some grant recipients. Similarly, privilege also applies to mental health providers and attorneys, but it also applies in the context of clergy, spouses, and the context of self-incrimination. So the clergy parishioner privilege prevents clergy from testifying about information that one of their parishioners may have shared with them. There's also a spousal privilege that prevents spouses from testifying against one another in court. And the privilege against self-incrimination is a protection guaranteed by the Fifth Amendment of the US Constitution that says that people cannot be required to testify against themselves in any way that could incriminate them in a crime. And it's important to point out that in Maryland, while medical providers are covered by confidentiality, there's actually no testimonial physician-patient privilege outside of the mental health field. So only mental health information and records are protected by privilege. So where do these protections come from? Confidentiality and privilege are both derived from multiple sources. Confidentiality is often found in professional ethical rules and licensing rules. You may also find rules about confidentiality in the internal policies of your organization. And then additionally, many of the grants that advocates work under impose requirements to maintain the confidentiality of client information. For example, VAWA and VOCA both impose confidentiality requirements, and it's important to make sure that you are aware of what your grants specifically require. And finally, the rules about confidentiality may also be found in statutes under both state and federal law. By contrast, privilege is strictly a legal doctrine that can be found in both statutes and common law under both state and federal law. So here I have an excerpt from the VAWA statute, which imposes its own confidentiality protections as an example. So the statute in essence states that in order to ensure the safety of victims, that the recipients of funding under VAWA shall protect the confidentiality and privacy of those who receive services. There are no exceptions to the confidentiality rule for grant reporting under VAWA. So what this means is it is very important for everyone who works under VAWA to use a high level of care when providing case story examples for grant reporting to ensure that when you include those case stories in your reports, that no confidential client information is revealed. There is similarly no exception under VAWA for collaboration, which means that organizations may not disclose confidential client information while collaborating with external organizations. Internal data sharing of confidential information is also not permitted under VAWA, and organizations may not require the sharing of confidential information as a condition for providing services. So in other words, during the intake of a potential client, organizations may not require the person to waive confidentiality as a condition of receiving services. And finally, under VAWA, parents and guardians can provide the release of confidential information for an unemancipated minor, but not if the parent or guardian is the alleged abuser. There also may be other laws in addition to VAWA that provide even stronger protections to children. Another important aspect to understand about VAWA is that VAWA does not provide privilege protections, meaning that VAWA does not protect advocates and other professionals from being compelled to provide client information in court. If you do receive a court order or a subpoena to disclose confidential client information, VAWA does, however, require that providers attempt to notify the client beforehand. And the last thing I want to point out about VAWA is that while it does not provide privilege protections, depending on the services that you are providing, other legal privileges may be invoked. So for example, if you have attorneys that work at your organization and someone tries to compel an attorney to disclose their communications with the client about a case, they may invoke the attorney-client privilege. So each of the privileges, while they may overlap, are distinct from each other. And just because your grant might not provide privilege protections does not mean that there aren't privilege protections that arise from other sources. So now I want to give a bit more in-depth information about confidentiality versus privilege. Both confidentiality and privilege belong to the patient or client, not to the advocate. So this means that generally only the patient or the client can waive confidentiality or privilege, and they must give consent for the release of their information. There are some exceptions to this general rule, which I have listed on this slide. So one exception is the mandatory reporting of child abuse or the abuse of a vulnerable adult. Advocates should consult with their organizations or with an attorney to determine whether you are a mandatory reporter under the law of the state that you're practicing in. So not all service providers are mandatory reporters. For example, attorneys are not mandatory reporters, but many of you that are working in different vocations may be. Another exception to the general rule is that parents or guardians may be able to waive confidentiality or privilege for minor children. And finally, there are some other exceptions that vary based on profession. So for example, in the mental health field, confidentiality may be waived where a patient is a threat to themselves or others. Or in the medical field, there may be exceptions for malpractice claims. So you always want to check with your legal counsel to make sure that you are following the law and the ethical rules of the profession in your state. Another important aspect of waivers of confidentiality and privilege is that they are all or nothing. This means that a person cannot try to waive confidentiality or privilege for some information while maintaining confidentiality or privilege over the rest of the information or communications. So I have here on the screen an example, but I do want to give a trigger warning first that it talks about an instance of physical and sexual abuse. So if you need to mute the presentation for the next minute or so, please feel free to do so. The example states that Maria wants the Rape Crisis Center advocate to give expert testimony that Maria's husband physically and sexually abused their 6-year-old daughter, but not that Maria waited a month to go to the police after she found out about the abuse. Due to the all or nothing rule, this is not possible. If Maria waives privilege over this information in court and the advocate testifies about the abuse, then the advocate could also be compelled to testify about the fact that Maria waited a month to go to the police. So the all or nothing rule is definitely something that advocates should discuss with their clients when determining whether an advocate can or should waive confidentiality or privilege protections. So why do we have confidentiality and privilege rules? These protections are designed to encourage survivors to seek out services. If survivors believe that the private information that they need to provide is discoverable by third parties, they might be inclined to not come forward and to not seek the services that they need to address the different issues that they're facing. Privilege and confidentiality encourage free and effective communication between survivors and advocates. These rules also serve to protect children who do not have the capacity to protect themselves. Within the framework of privilege, there's something that we call uber privilege. Uber privilege is essentially an extremely strong super privilege that is given to the records of attorneys and to clergy. So these records are very, very hard, if not impossible, to obtain because they are so strongly protected. However, other records protected by privilege, such as mental health or social work records, may be easier to obtain because they are more likely to be relevant to a case. Any damage from breaking privilege or waiving privilege over mental health records or social work records is generally seen as being less severe than if attorneys or clergy are forced to turn over their client communications. Now I want to talk about the release of confidential client records. So why and when can or should an advocate release confidential client records? There are a few scenarios where this may happen. The first is with the written release from a client. So we recommend that when you get a release from a client that you use a HIPAA compliant model release. Your organization should have a template on file, and we recommend making sure that you review that form with the client and explain what every section means. You may receive a request from the survivor's attorney. So for example, the attorney may request confidential information to use as evidence in a peace order case or a family law case. And in that scenario, the attorney must provide you with a written release that has been signed by the survivor. The state's attorney's office may also request confidential information, and again, they will need a written release or a subpoena for that information. And then another situation is if the perpetrator's attorney or defense counsel issues a subpoena for that information, or if the court issues an order requiring the disclosure of that information. There are some steps that we recommend advocates take when responding to requests for release of client records to ensure that the response is client-centered and trauma-informed. So first, you should have a conversation with your client regarding the request and find out what it is that they want. So the client may be okay with the information being shared, or they may have a strong desire to keep the information private. You'll also want to discuss the pros and cons of releasing that information with the client and provide information to the client about what the potential implications could be that would follow from releasing the information. This is really important for ensuring that you have received informed consent from the client prior to releasing any of their confidential information. You will, of course, also want to ensure that the release of information is made voluntarily by the client and not because the client believes that they must sign the form in order to receive services. And then finally, as I've mentioned, but very importantly, the release must be in writing. So as I mentioned, we recommend that you use a HIPAA-compliant model release form. There are some special requirements depending on the type of records that are being released that you may need to adhere to. So for example, I have included on this slide a list of types of records that may have special requirements for release. For example, in order to release records of drug treatment, the fact that the records are for drug treatment must be specifically noted on the release form. It cannot just generally say, for example, medical records from XYZ date range. You may also need a specific release form for those records. So you'll want to check with the law of your state to determine whether certain record types have special or additional release requirements. Another unique situation is other provider records. So for example, if you request records from provider A, they may have records on file that they have obtained from provider B. So this involves 2 levels of confidentiality, and you'll want to make sure that you have informed consent for the release of both providers' records if you want to obtain the records for provider B from provider A. Another important component to releases of records is to make sure they are reasonably time limited. You don't want the release to be open-ended with regards to how long the release is in effect for, because you don't want a release that could just go on forever. We always recommend that rather than accepting release forms from other agencies to release your client's records, to draft your own release forms so that you know exactly what it says, exactly what it provides for, and exactly how long it lasts. We also recommend including in your policies at your organization a requirement that a discussion is had with your clients prior to the release of any information to ensure that the release is voluntary and informed. So as I mentioned, one of the steps you will want to take with your clients prior to the release of confidential information or records is to discuss the pros and cons of releasing the information. I have included here some of the general pros and cons, though there may be others depending on the specific facts of the client's situation and the type of records requested. Some of the pros are that advocates' records may be valuable evidence that can be used to support the survivors or the state's case against the perpetrator. Another pro to releasing records is avoiding an inference by the court that the records would have been damaging to the survivor or the state's case. So if a survivor refuses to waive confidentiality, sometimes the court may assume that the records would have been harmful to their case, even if this isn't true. So releasing the records helps to avoid that. Some of the cons of releasing advocate records are that the survivor, of course, loses their privacy, as well as the fact that the waiver is all or nothing. As I mentioned, if a client chooses to release part of a record, then the entire record may be disclosed and become known to others and potentially could be used against them in a case. So now I want to switch to talk about subpoenas. What do you do if you receive a subpoena? This is very important, and we always recommend notifying your supervisor, your director, or your legal counsel immediately. You want to treat the receipt of a subpoena as urgent because if it's handled in a timely fashion, there are actions that you or your organization can take to fight against the subpoena. When you receive a subpoena, you do not want to turn over the records right away. You'll want to analyze the pros and cons of providing the records, as well as talk to the survivor to find out what it is that they want. You might determine that the best course of action is to fight the subpoena. There are some special requirements for subpoenas. In criminal cases, the defense counsel must notify both the victim and the prosecutor of a subpoena for medical records. Under HIPAA and state law, advocates are required to notify patients when health records are subpoenaed, and the patient must be given reasonable time to file a motion to quash the subpoena. And finally, the subpoena of financial records also requires that the client be provided notice of the subpoena. When you receive a subpoena, you will need to get in contact with a lawyer. The lawyer will likely need a copy of the subpoena or court order, a copy of the records that are being requested, the service provider's credentials, the supervisor's credentials, any grant supporting services, and the date that records or testimony are required to be released by. This information can assist the attorney in filing a motion to quash, which is a motion that gets rid of the subpoena and it releases you from the obligation to provide the records. There is a time limit to file a motion to quash, and that's why it's a very urgent matter. A judge will review the motion and decide whether or not the records must be provided. This is why it's important not to hand over the records right away and to speak with legal counsel first, because you might not need to turn them over. So the next topic I'd like to talk about is advocate testimony. And we have here a photo from the film My Cousin Vinny. If you've seen it, it's a great example of expert testimony that's given in a criminal trial. And if you haven't seen it, I'd recommend watching it if you have the time. It's a great scene. So what is advocate testimony? There are two basic types of advocate testimony that I want to talk about: expert witness testimony and fact witness testimony. So first, an expert witness is a witness who has some specialized knowledge, skills, or experience in a particular field or discipline that goes beyond what would be expected from the average person. Expert witnesses can help to educate the judge or the jury about a technical or specialized body of information, and they can give their expert opinions about a specific case. For example, an expert witness could be called in a sexual violence case to talk about the impact of trauma on witness recollection. By contrast, a fact witness can only testify from their personal knowledge. So this is information or facts that the witness has specifically and personally observed with their own senses. This means that advocates can testify about the personal knowledge they have of services that were provided to a specific survivor and how that survivor may have responded to the services. Oftentimes, advocates can actually serve as both types of witness, both expert and fact witness, in the same case. What are some topics that may be useful to have an expert testify about in a case involving sexual violence? So unfortunately, in this field, judges and juries are still very uneducated about how trauma and the cycle of abuse can impact survivors. Advocates can actually provide extremely helpful information then to judges and juries about topics that include the cycle of violence, delayed reporting, the effects of trauma, and other topics that help to understand survivor actions and reactions in a given case. Some helpful testimony that fact witnesses may provide includes the observations that they made of the client, their observations of the opposing party, and their observations of the interactions between a parent and child. So advocate records. Because advocates could be called to testify in cases, they should keep in the back of their mind, they should keep the fact that they could be called to testify in the back of their mind when they are conducting their record keeping. So you want to keep records in a way that gives context to any bad facts. It's better to have that context already recorded in the records rather than try to explain any bad facts while on the witness stand. So again, another trigger warning before I read this example, because it references a sexual assault. But an example of a bad fact that could be included in a report is client appears to be an alcoholic. This is a fact that could be used against the client at trial. However, with context added, that note might read, as is typical for many sexual assault survivors, client self-medicates with alcohol. Instead of just stating the observation, you can provide helpful context that can better assist a judge or a jury down the line in understanding the observation that you made. Now, why might you want to testify as an advocate? There are pros and cons to testifying. Pros include that as an advocate, as a fact witness, you can corroborate a survivor's version of events. Corroborating evidence is evidence that supports that it is more likely that the survivor's testimony and accounting is true. Additionally, an advocate, as an expert, can help to explain the survivor's behavior and minimize victim blaming by the judge or the jury. Some cons of testifying include, again, of course, the loss of privacy to the survivor, but also the fact that the advocate will be subject to cross-examination by the perpetrator's attorney, which can be a very stressful experience. There are also limitations on fact witness testimony. So, for example, advocates cannot testify regarding any hearsay. So there are some exceptions, but generally, you cannot testify as to what someone else has told you. You can only testify as to what you observed yourself. So what you saw, what you heard. There are some steps that you can take in preparation for testifying. So first, you can review your prior records, but you should only do this if you are advised to do so by counsel. That's a strategic decision that you'll make with counsel. If you are testifying as an expert, you can provide your resume or CV. We recommend that you don't use your home address on that document to keep that confidential for yourself, and then ensure that the document is up to date. If it's appropriate, you can also have a conversation with the attorney who's planning to call you as a witness to get a sense of what they plan to ask you about. And your own attorney might also conduct trial preparation with you to help you prepare to give your testimony. So next, I want to give some tips for testifying. First, make sure that you stay as calm as you can. Testifying can definitely be stressful for people because it involves public speaking and it's adversarial in nature, especially on cross-examination. So do what you can prior to trial to just get yourself in a relaxed headspace. When you're answering questions, it's important to pay attention to the question asked and only answer the specific question that is asked. It can be very easy to go off on a tangent or to provide additional information that doesn't directly answer the question, and the judge or the attorney may take issue with your answer. We recommend that when answering questions that you take a quick moment to think about what information is being asked of you and to consider your answer before responding. Another important tip is to not guess at the answer to a question. So it is perfectly okay when you're asked a question to say, I don't know, or I cannot recall at this time. But if you give an affirmative answer that you're not actually sure of, that will be in the record and you could be accused of lying later on, and that could really hurt your credibility and the case as a whole. Be sure as well that you're only answering questions and that you don't play lawyer. So judges really do not like when witnesses address attorneys or other witnesses while they're testifying, or really at any time. So the only time I would say that it's okay to not answer the question and to speak to the attorney or judge is if you don't understand the question and you need some clarification. It is okay to talk to the judge or jury. And when you're testifying, you're actually going to want to turn to look at the judge or the jury because those are the people that you're giving your testimony to. And that can also help you to better connect with the judge and the jury. Another tip is to stop talking if you hear someone say objection. This means that one of the party's attorneys is objecting to a question that was asked, and they're arguing to the judge that the question or the answer to it is improper and should not be allowed. If the judge says sustained, that means that the objection was deemed valid and you should not answer the question. If the judge says overruled, that means that the objection was deemed invalid and you can go ahead and answer the question. If you are ever uncertain, you can always ask the judge, may I answer? It's very important to make sure that you understand the question before answering. So you do not want to accidentally testify to something that's incorrect or untrue and have that damage your credibility later on. Sometimes questions are asked that are just worded in a confusing way. They might have a double negative in them, and it's not clear what a yes or no answer would actually mean. So it's okay to ask the attorney to repeat or to clarify the question. And then, of course, just make sure that you're respectful when you ask that and that you aren't coming across as argumentative. So the style of examination in court or in a deposition is not a conversation. It's in the form of question and answer. So you want to make sure that you are just answering the questions asked and that you don't give testimony beyond that or try to engage in a back and forth with the attorney. Again, of course, other than the clarifying questions when you don't understand. Be very careful to be accurate in what you're testifying to, especially when it comes to dates and times, because your testimony becomes an official record. Do not agree with anything just to be polite, especially on cross-examination. The opposing party is going to try to trip you up, and they're going to try to trick you. So you want to be on guard and be very intentional, accurate, and clear with what you're saying. And remember that opposing counsel is never on your side. It's also important to remember that releasing records or testifying in one case can have an impact on survivors in future cases. So I'll give an example here and with another trigger warning as it does reference sexual violence. So for example, in a county with only one judge, a rape crisis center advocate agrees to testify as a fact witness about Valerie's sexual assault and as an expert witness about delayed reporting. What do we think the judge will expect the next time that she hears a sexual violence case? So the judge may still have what the advocate testified to regarding delayed reporting in their mind when they are overseeing the next case. That may be useful for subsequent cases, and it may mean that the judge has a better understanding of delayed reporting and that the advocate won't need to testify in every case because the judge has been educated about these topics. So now we're going to talk for just a few minutes about ethics and specifically the unauthorized practice of law. So what can you do as an advocate to avoid the unauthorized practice of law? Non-attorney advocates can provide victims with basic information about the existence of legal rights and remedies, and they can provide victims with basic information about the manner in which judicial proceedings are conducted. So again, the emphasis here is on basic information. You are not applying the law to the facts of the client's specific situation or providing the client with your idea of what the legal outcome could be. Non-attorney advocates can also assist a victim to prepare a legal pleading or legal document on her own behalf by defining what the unfamiliar terms are on the form and by explaining where on the form the victim is to provide certain information. And if necessary, the advocate can help by transcribing or otherwise recording the victim's own words verbatim and they can sit with the victim at the trial table so long as it's permitted by the court. Now, what can advocates not do? In other words, what could possibly constitute the unauthorized practice of law? Advocates cannot provide advice relating to a victim's rights or remedies, including suggesting the pursuit of any particular remedy. They also cannot provide information about the legal aspects of judicial proceedings. So, for example, how to present a case, how to call witnesses, or how to introduce evidence. Advocates also cannot use their own language in preparing or filling out form pleadings or other legal documents. And they cannot engage in advocacy before any governmental representative on behalf of an individual victim. And that concludes my presentation for you today. I can put my email in the chat, so please feel free to reach out to me directly or to Sally if you have any questions about the information that was provided. And if you have a client who requires legal assistance in connection with a sexual assault, please feel free to provide them our main line. And if they call in, we can conduct an intake with them to assess what their legal needs are and whether there's something that we can assist with. And I believe I will now pass the presentation on to my colleague, Juan Luis, for the next segment.
Yeah, Stephanie, as we are letting Juan Luis get set up, thank you so much for your presentation. Any questions for Stephanie before she logs out of her presentation, please put them in the chat. She's just put her email in there, so you are welcome to email her as well. Great. So Stephanie, if you want to stop sharing your screen, we will let Juan Luis get set up and continue on with the next part of our presentation.
Sorry, trying to figure out how to stop sharing.
Yeah, no problem. There should be there we go. So there should be like a thing at the top of your screen that says stop sharing.
Okay. There we go.
Yeah.
Figured it out.
No problem. So Juan Luis, if you want to start sharing your screen, I will do a little introduction. So Juan Luis is our senior legal advocate. He's been with MCASA working with directly with survivors for many years and has a lot of information to share this afternoon. So with that, Juan Luis, I will turn it over to you. Thanks for being here today.
Oh, good morning. Please allow me a moment while I try to figure out how to share my slides. Oh, there it is, I think.
Yeah, there should be a little thing at the bottom that says share. So for those of you on the call while Juan Luis is setting up, a lot of us switched over to Facebook Workplace since the beginning of the month, and everything feels like it's in a different place. So we greatly appreciate your patience as we encounter some of these very small technical issues when we're figuring out this new platform. Juan Luis, this looks great. I can see it on my screen very clearly. Yep.
Nice.
So
Okay.
turning it over to you. Thank you.
Yeah, thank you. And you can hear me okay?
Yeah, we can hear you great.
Okay, nice. So, good morning. My name is Juan Luis Ayllon Quiros. I am senior legal advocate with Sally, or Sexual Assault Legal Institute. So I work with Stephanie Breen, the previous presenter, as you probably heard probably a few times by now. Sally, we're the Sexual Assault Legal Institute, the legal arm of the Maryland Coalition Against Sexual Assault. So I work with a team of lawyers that serve survivors with sexual assault. We, on offer consultations and represent survivors in a whole range of different types of cases. And me and the other legal advocates on our team, we're there to assist survivors and our attorneys throughout the case. We're the first point of contact with our office when somebody gets referred to us and calls in for services. It's me and our other advocates. We conduct the intake process, so we interview survivors to get the information about their case, so that an attorney will be able to review it and offer services. We also help out with whatever else needs to be done to help keep our legal services running. And we do, many of us also speak Spanish and English, so we do a lot of translation and interpretation for our Spanish speaking clients. Basically, we're part victim advocate and part legal assistant. As part of our intake process, we also conduct safety planning. It's a conversation with the survivor about what are their concerns about their safety and how we may be able to, or what their options are to deal with different concerns and different threats or risks. So I'm going to be talking about that, and I'm going to be offering some tips, some ideas about the types of questions that we either ask the survivor that we're working with. We may ask that question explicitly, or questions that we keep in our mind as we converse with them about their safety concerns and their options and the situation overall. So let me see if I am able to. Yes, I can scroll slides. Okay, so what is safety planning? I have this definition here from National Network to End Domestic Violence. A safety plan is a survivor's individualized plan developed in partnership with an advocate that focuses on strategies for staying safe. It's typically used with survivors of domestic violence, sexual assault, dating violence, and stalking. And in creating a safety plan, advocates discuss the unique needs and circumstances of individual victims. Give me a moment here. Oh, sorry, 1 second. Let me address my technical difficulties for a moment.
Come on, Luis, if there's something I can help with, please let me know.
Well, sorry, it was
Oh,
not
yeah.
it was it was more to do with the physical things in front of me.
Okay.
Yeah. So just so you all know, let me get back into it. The safety plan um
We
can
can't
mean
see your
different things.
we can't see your slides, so if you can put
Oh,
those back up.
yes. Um, there we go.
Perfect. Yeah,
Um,
we can see it. Great.
Okay. Um, so that definition is about domestic violence. We work with, obviously, with sexual assault. There's also safety planning in the area of mental health, which is more about self-harm and suicidal ideation. But a lot of this, so the definition that I read about domestic violence is very similar to what we do. A lot of it will apply. Um, it's about dealing with external threats to somebody's safety and where somebody may be trying to do harm to a survivor. Um, so what is our objectives for safety planning? What is our objective when safety planning? Basically, is it working? Yes. Our goal is to reduce the risk of any further harm. We're limited in what we're able to do because we're somebody talking to them over the phone. We can't physically walk to their home and check their locks on their windows and their doors, for example. So what we're doing is having a conversation. We do the best that we can from our position, from our desk, to try to give people some ideas about how to stay safe and get them to think about their risks and their options. We can try to get them to take inventory of their situation and then think about different risks and different resources. Um, Unfortunately, safety planning is not a guarantee of safety, but the idea is to improve the situation, as best as we can. So during safety planning, these are some things that we're going to do. So we're going to try to identify individual risk factors, and this can mean looking at their immediate surroundings, like I talked about the doors and the windows. Uh, it can mean looking at their relationship with the perpetrator, if it's in the home or at work or whatever that may be. And we'll talk about this a bit more later, but it can also mean thinking about the survivors' identities and their characteristics, their nationality, their citizenship status, their economic circumstances. Any number of things can play into this and interact with different risk factors. We also want to try to increase protective factors. So we will think about a survivor's support networks and their physical environment. Do they have ways of getting to safety? Can they physically access escape routes? Do they have access to transportation? Do they have friends and family that they can rely on for support? Reduce stress during crisis. So that's another objective, is to help people feel less stressed. Stress can definitely wreck somebody's health and their ability to think and to function properly. And so having a sense of what are their options and their resources can help with that. We can encourage people to think through different challenges and come up with ideas of what they would do in different situations. Hopefully having some kind of plan can help reduce this uncertainty and the anxiety and stress. And empowerment. We seek to empower survivors. We want survivors to feel that they're in control of their safety as much as possible after a violation, to reclaim a little bit of sense of power and agency over their situation. So our hope is that by talking about it and talking about what's in their power to do, that can be empowering. So what do we do? In our experience, we found it most effective to treat safety planning as a collaboration and a conversation with a survivor. We come to it with our some questions, tips, tricks. We come to it with our empathy and our knowledge, and maybe try to be think about someone's specific circumstance creatively. But every time we have this conversation with a survivor, with a new client, we have to be ready to have a different conversation with a different person. So it's never exactly the same. The person is going through their own unique situation. And so every conversation, every safety plan is going to be tailored to the individual person and their needs and circumstances. Depending on what these needs and these circumstances, the conversation can be very brief. It can be if somebody is physically safe, it can just be talking about vague potential risks like social media privacy settings, or it can be a long discussion about if there's physical threats, imminent threats. It can be a discussion of specific plans and logistics, or it can be anything in between those two things. So typically, I will approach this as a conversation. We ask the person if they have any concerns about their safety, and from there, the conversation will be very different depending on their answer. It will go wherever they want it to go. Sometimes if there's a specific concern based on something that we discussed earlier during the call, during the intake interview, we make sure to come back to that issue to discuss that during safety planning, to see that they have the resources to handle that particular issue or some ideas. Now, we always try to keep in mind that when we're talking to a survivor, they are the expert when it comes to their life. We can try to provide an outside perspective and ask some questions to encourage them to think about different problems and different options. And hopefully that will be helpful to them. But I try to always keep in mind that I can't be the expert on how to plan for all the circumstances of their life. I can't tell them what to do. Especially in a case where the abuser is someone close to them and someone that they know well. They're going to know a lot more about what that dynamic is in that relationship. That they're going to know more than I could learn and talk by talking to them for an hour or two. They're going to know this person's character and their idiosyncrasies and how they might react to different things. So the survivor is in charge, and we're there to consult and ask hopefully helpful questions to get them to consider things and to make suggestions in response to their answers. So listening to their concerns and their answers and respond to that. Now, helping survivors. So speaking generally, there's any number of different settings where people may suffer a sexual assault and that they may have to different settings that we may have to help a survivor navigate after an assault. So I'm going to introduce some examples of images of different types of settings and cases that we may come across, because safety planning is not one size fits all, and it has to take into account the specific circumstances of the survivor. So with each of these different settings, there will come different constraints and different challenges and different resources and opportunities. We're going to have to, again, in every safety planning conversation, think about or help them really think about the exact circumstances of their situation. But here's some, and come up with responses to their particulars. But here are some examples of different types of environments that we may encounter commonly when working with survivors of sexual assault. I'm going to make some different images appear on the screen. So here we have what looks like a school or university or some kind of campus. The education environment is one type of setting that we see often. So On a college campus, the perpetrator can often be a classmate or somebody in the survivors in their friend group, maybe a friend of a friend or someone who lives down the hall in the same dorm building. In that type of setting with that type of social network, that will have its own set of challenges, and of course, it can affect access to education for a survivor. There's also unique types of resources that a survivor in a different setting would not have exactly that, like teachers or counselors or resource officers, classmates, friends, depending on the case and the specific conversation that we're having with a survivor, we can talk about using some of these resources on campus to help them meet their safety goals. Now, here you see a few different types of work work settings. So, and that's another common scenario for survivors, the workplace. Unfortunately, I've worked with a lot of people who have been abused by a supervisor or a boss at work. Unfortunately, it happens a lot to undocumented workers. And there's a lot of different types of workplaces, but the different resources there may be the supervisor, that a trusted supervisor, coworkers that are sympathetic and trusted, a human resources department where that's available. Then here I have a picture of a living room to illustrate the concept of the home. A lot of the time, the abuser can be somebody who lives in the same home, a spouse or partner, even a parent in the same household as the victim, or housemate, roommate. So in these situations, we have to think about the immediate safety a lot of the time, the moment that they call us sometimes, and depending on the abuser, the relationship with them. If the survivor is worried about possibly retaliation, we have to think about how the survivor can protect themselves without raising suspicions. They may have to be discreet if they're going to reach out for help or report their abuser. So resources to consider in that type of setting can include family members or members of the same household or other roommates or housemates, a trusted neighbor, friends or family. And when there are threats of violence or there's actual violence, sometimes law enforcement may be the only or the best effective option. So we would have to think about a survivor trying to always have access to a phone and access to a charger and to have emergency services on speed dial. And the question mark meaning everything else and everywhere else. There's all kinds of different settings. There's some common situations that we see, but every time, every safety plan is going to be different from other situations depending on the specific details. So generally speaking, when thinking about safety planning for survivors, we want to keep in mind the context of where the abuse is coming from. The situations can be very different. It can be an intimate partner. It can be in a dating context on a first or a second date. It can be child abuse by a family member or a teacher. It can be a stranger, or it can be a known stranger, like somebody the person recognizes from seeing them at the bus stop or seeing them in class or seeing them around the neighborhood. Whatever the case, so for example, in the case of the bus stop, we have to think about how to be safe in and around that bus stop or that lecture hall or whatever it is that they may encounter this person. So we have to troubleshoot different issues and use our best understanding and of the situation. In our office, we normally talk about safety planning at the end of our intake interview. So by this point, we spent a good while learning about the case as much as we can as part of our intake process. So towards the end of the call, we'll have a pretty good sense of the whole picture of the case and the person's circumstances. So we have as much information as possible to try to help troubleshoot different possible issues. And so we can tailor the conversation to their specific needs as we understand them at that moment. We're going to want to consider that survivors may already be connected with different resources like school counselors or police officers, or human resources at work, or a doctor, an advocate, a lawyer, whatever it may be. If they're not, we may be able to encourage them to make these connections. We have to consider a survivor maybe already has talked about safety planning with one of these professionals. A lot of times, frankly, they will have thought about these issues by themselves on their own. So that's why we ask them about it. It's a conversation and not a list of these are things that you need to do. We ask, have they had this conversation? What did they discuss? Have they thought about this? Do they have any new concerns since having had that conversation, or any new issues that came up? We can try to supplement what they've already worked out. We can find out what steps they've taken and take it from there. Now, let's see, intersectionality. So when thinking and talking about somebody else's safety, is probably a good thing to keep in mind that this is not for ourselves, and so to be aware of the ways that the other person is different from us and how this can affect what their options will look like. That's where we get into the idea of intersectionality and taking into consideration how different backgrounds, different identities, different statuses can affect someone's experience and how they're treated in society. So depending on the work that you do, the geographic area that you serve, or the type of population that you work with, you may come into contact with survivors from different types of backgrounds. A lot of times, survivors may face very serious barriers to get help if they're a member of a minority group or a lower status group. One example that I'm very familiar with is our Hispanic clients. Many of them are first-generation immigrants. They're undocumented and they don't speak English very well, or they don't speak English at all. In that situation, what I see often is if somebody's the victim of a crime, they're in a foreign country, the police don't speak their language, the courts don't speak their language. It's going to be very, very hard for them to even ask for help. It's going to be very hard for them to receive help, to understand what somebody's offering them or trying to assist them with. Now, if you add to that the fact that they may live in a small immigrant community or a small immigrant neighborhood where everybody that they have access to, everybody that speaks their language or that they could talk to, they all know each other, and maybe they all have some connection to their abuser. Maybe they sympathize with the abuser since it's somebody that they know. So that can make it even harder to speak out if the abuser is also a member of the same community. A lot of times they are. Plus, a lot of times they will also be in the same household as well as it will be a partner or a spouse a lot of times. So, but this applies to, it's not just for Spanish-speaking immigrants, it's for small communities of all kinds. It can be people from rural areas, it can be people from different religious communities, people from certain communities of color or sexual minorities might feel unsafe around law enforcement or police officers. They may have some distrust towards law enforcement or the state. Other people, they may fear that they're less likely to be believed as victims because of their sex, their race, or their sexual orientation. Another consideration is economic status. That can be a very critical factor. Like a survivor would know income is going to have a very, very hard time leaving their abuser if they depend on this person financially for support, to have a roof over their head. Somebody struggling with poverty, they may not be able to leave their job if they're being harassed at work or abused at work. They may not even be able to pay their phone bill this month. We've had, unfortunately, cases where we lose contact with someone for a couple of weeks because they couldn't pay their phone bill. So they can't call for help for a bit. Now, safety is more than just avoiding physical violence, of course, and that can be harder to access for some. So while we all may have access to the same resources legally or theoretically, it can be harder to do that if you don't have easy access in your everyday language, or if you don't have time because you're working through shifts or you don't have a place to live. On the flip side of this issue of intersectionality, there are different identities or experiences that can privilege and benefit somebody. This is, for example, this example is maybe a little obvious, but I've seen survivors that don't struggle with English. They're going to feel a lot more comfortable talking to law enforcement, or a lot less uncomfortable when trying to make a report or seek help. It's self-evident, but if you flip it and look at it from the other side, it might help understand the challenges for the person that doesn't speak English. Another obvious example, somebody with a middle-class income, they may be, it might not be easy, but they might be able to afford to relocate to a different neighborhood or a different city for their safety. They may be able to afford to sublet a room if in case of emergency. As a personal example of intersectionality, not in the context of safety, but me myself, I can talk about ways that I am benefited and minor inconveniences from the ways my background and identities. For example, I'm also a Spanish-speaking first-generation immigrant, and I have a slightly darker skin color. People don't see me as white, but here in this country, that this intersects with my middle-class background. Where I grew up, I grew up middle class, and then I got to go to college here, and I can speak English like somebody that went to college. So I have a job and I have an income that I sometimes I can afford to go see my family in Peru. But on the other hand, in my case, I have this very, very minor disadvantage. When I travel to see my family, I get randomly selected to get my back searched a lot more often than some people. That's not it's a tiny little problem, but just an example of how the way I'm perceived and my background can intersect to come together to shape my options, the options that I have available to me and my experience. And I'm sure many of us can think of different examples from our own personal experience with our intersecting identities. One last thing I want to say on intersectionality is that we can't possibly know everything about every type of person that can exist. We can't possibly just memorize all of the things about all of the categories. The important thing is to approach a conversation with another person with humility and an open mind, to be aware of our own privileges, our own biases, and be mindful of where we're coming from, and not assume anything about someone else. Be ready to listen to them and to adapt according to their answer. There are lots of cultures and life experiences that I may not understand fully personally, but I can try to listen to their situation and their concerns, and I can try to offer resources to help them make it through this situation and come out of it. So risk assessment. What is risk assessment? Is analyzing a person's situation to identify potential hazards and try to anticipate what would happen if something, if A happens, what would come out of that. So I have some questions on the slide about different different things that we might want to explore with the client to brainstorm possible scenarios. For example, the first thing, are you safe now? Is it safe to contact you? This lets us have a baseline sense of the safety situation. The first time that a survivor contacts our office, we ask and we confirm that the number they provide to us, that it is safe to call them at this number, that it's safe to leave them. I'm sorry, that it's safe for them. If we leave a voice message saying that we're calling from Sally or the Sexual Assault Legal Institute, when somebody answers a call at this number, when we call this number, is it safe to say where we're calling from? Is it safe to contact via email? Is it safe for this person to receive letters or documents related to this case at like, do they have a mailing address where it's safe for them to receive documents without running the risk of their sensitive information being intercepted and exposing them to some kind of retaliation? The other questions here will also give us more information to explore the I guess the safety situation. Like, the next few questions are about actual and potential contact with the perpetrator. Like, have you seen or had any contact with the perpetrator? In what ways may you come into contact with them? Have they contacted you and you contacted your friends or family? Another thing we can do is to try to get a sense of what is the survivor's life routines and what times and places they might run into, or they might run the risk of harm from the perpetrator. So do they know where you live? Do they know where you work? Where you buy your groceries? Where you bank? These questions might help us get a sense of what are the different risks. And for each possible risk, then the survivor can try to imagine with our help what are possible solutions and come up with contingency plans. Like, for example, can they buy their groceries at a different store? Can they go at a different time of the day so that the abuser it won't be as easy to predict or anticipate their routine to intercept them? Can they deposit their checks at a different branch? Can they bring a friend or somebody they trust or a family member with them to do things, to accompany them to do things? So they can try to come up with different possible responses for each of these issues. Now, at home, if you're at home and under threat or attack, I want to review a few tips for the specific scenario of the home, where this can come up a lot, where the abuser is a partner or somebody who lives in the home. But that's not the only way. Sometimes, they may be at home and somebody else that knows where they live can come look for them in their home. So if you're at home and under attack, stay away from kitchens, places with weapons, small spaces where a perpetrator could trap you. Go to a room with a door or window to escape. These things are a bit obvious, but what I was told when I was first learning about this is that people's first instinct when they're under attack is to get away from the threat, of course, and to put some kind of separation, some barrier between themselves and the threat. So sometimes in the home that can end up with somebody who's inside of a closet, inside of a bathroom, behind a locked door, and they're safe physically in the moment, but they may not have any way out of there. They're safe with the abuser on the other side of that door, and no way to call for help potentially. So that's why that's a suggestion to bring up, something that one of the first things I learned about this. So I always try to help people mentally take inventory of what are their options in their home, what are the entrances and exits that they may have access to, what rooms will have options to get out, and which rooms in the home will not, and that kind of thing. Yeah, a room with a phone and a locking door to allow you to call for help. If something happens at home, of course, the thing to do is call 911 and provide the information to help them find the survivor. It can be very helpful to get the person's name that one speaks with, or ID number, in case they have to call back, so that they can talk to someone who's already helped or already familiar with the case. Excuse me a moment. Other things to consider at home. Become familiar with local safe places. That can include a trusted neighbor or friend, a family member that lives close by. It can mean the local church, the police station, a domestic violence shelter, any public space where other people may be around to act as deterrent. It's probably a good idea to memorize the route to the nearest safe place. Changing locks on doors, checking locks on windows, changing security codes. In the case of a perpetrator that lives in the same residence, if they have moved out, that's a good time to change the locks to make sure that they can get back in. Confirm that you have sufficient and functional outdoor lighting. This, of course, depends on the type of housing, but having outdoor lights can act as a deterrent also. Motion activated lights can alert the survivor inside the house that there's something going on outside. It can maybe deter a offender by making them think, if the lights go on and they're trying to approach, it can make them think, there is light, and now people around, they might be able to see me approaching this house. So they might think twice about doing that with witnesses. Make an escape plan. This is related to the first point of becoming familiar with safe places. But we can encourage the survivor to think about where they could go if they need to escape, and to make a plan for that. If they have children, make sure that the children know the plan and have practiced it. Prepare an escape bag. Survivor who is thinking about leaving a home or an abuser, and they're anticipating any potential attacks or retaliation, they could consider packing a bag with important things that they might need if they have to leave quickly. So that can include clothes for a few days, prescription medications, or any important documents like identifications, insurance cards, any medical documents, passports, bank account information, whatever it might be, depending on their individual case. And they can store this bag somewhere safe in the house, where they can, on their way out, just grab it and go, or they can give it to someone that they trust, give it to a neighbor, a friend, or a relative to keep it safe away from the perpetrator. Ask trusted neighbors to call the police if they see the perpetrator at your house. If someone has a good relationship with the neighbors, the neighbors can be trusted. That can be a very powerful resource, because they might, they want there to be peace in the neighborhood. They might be nice, decent people that want the survivor to be okay. Another thing survivors can do is to prepare an excuse ahead of time. Think about what would they tell their abuser or the other person or someone else in the home, if they wanted to get out inconspicuously without raising any suspicion. So try to come up with different possible scenarios why they would have to leave at different times of the day or in different situations. Then when the day comes, something happens, they already have a reasonable explanation for why they're walking out, and they can use that to get away from a perpetrator. Um, another another thing have read about is a survivor can choose to maybe they can choose to sleep in the living room or some other public area of the house instead of a bedroom. That way, more people could potentially witness any abuse or hear or um, you know come across anything, and that could also deter a perpetrator. People can also hang bells outside of their door to act as an alarm to alert everyone around. Um, not exactly this is not exactly safety planning, but another thing I've seen in the home, in a worst case scenario, really is I've talked to someone who was trapped inside a room with the perpetrator on the other side, and they moved heavy objects up against the door to barricade themselves inside with furniture, while they were able to call for help. Um, this is, of course, not the ideal situation, not what I would recommend during safety planning, but that's something that I've seen work in a worst case scenario. So if the circumstances allow for it, it's something that someone could consider as an option, as a worst case scenario option. Um, now, outside of the home, how to protect yourself outside of the home. There's some different things that we might suggest for that, like changing regular travel habits. I alluded to this earlier, but it can make it harder for someone to anticipate their victim's routine and their moves, and make it harder for them to intercept their victim or to run into them and disrupt their day. Travel with others whenever possible. This is one of the first things that people instinctively want to do on their own. It's not like during safety planning, I tell them you should travel with others. They will usually, um, that's the first thing that people tend to think of. And it really helps them it really helps them feel safe, whenever that's available. Um, alternate where you do your banking, grocery shopping, and whatever else that you need to do. So changing it up can make it harder for someone to follow them. Um, cancel any shared bank accounts or credit cards. Um, just use cash or getting their survivors can use their own card or their own account if that's a possibility. Excuse me. Anytime someone uses a joint card or account that they shared access to with someone else, they may be sharing information about themselves, about their location, about what they're doing with their abuser. So that can be very important. In general, it can make survivors harder. It can make them safer and feel safer if they make themselves harder to follow, harder to trace, and just make their moves harder to predict. Um, so next slide. Safety in the workplace. In the workplace, some different things that we might suggest, and again, there's all kinds of different workplaces, but provide a picture of perpetrator to security and work colleagues. This will work in cases where the abuser or perpetrator is not a coworker that is known to the people at the work site. Talk to a supervisor to discuss what they can do to make it more difficult to find you. For example, remove your name or picture from a company website. Another thing that comes to mind there is physically moving the work area, the survivor's work area, to a more hidden away section in the office space or the whatever it may be, factory space or whatever type of workplace, or working as a team with or close by to someone that they trust, someone that makes them feel safe. Request that security walk through your mode of transportation. Similar to what the something I mentioned before about people choosing to bring a friend or do things with someone else. And if there's not a security staff, then a friend or coworker that they trust can be helpful for this similar purpose. Be sure to save any voicemails the perpetrator leaves at work, or any contact that can be that can come in handy later for any legal action or reporting. Campus, another common type of scenario that we see. So here's some tips for people on college campuses. Take different routes to class. Variation on the theme from earlier, becoming harder to trace and make the moves harder to predict. Know your resources on campus and off campus. Who would the survivor contact if they need help or if a friend needs help? It can be good to learn where the health center is on campus, where the police station is, where the sexual assault crisis center is. Are there counseling services available? Do they have the phone number for campus security? These are all different resources that can be helpful for somebody on a school campus to know. And if they have concerns about privacy in a smaller campus community, they can also try to figure out what are the equivalent services off campus in the surrounding community. Campus security, this will vary depending on the school, but some campuses have services like safe rides for people. They have a bus shuttle for people coming back to their dorm from the library at night, things like that. Request a schedule or a housing page. This can be done by talking to usually a dean or an administrator. Have backup plans. Think about plan B for potential bad situations. Do they know their campus address? Do they have that memorized? Do they carry cash on them in case something happens to their phone or their card? If they don't have their phone, is there anyone? Do they know someone's phone number? Do they have it memorized that they can call? If they have a car, do they have a spare key somewhere? Backup plans. Be mindful of victim blaming. All right, so partying is a big part of social culture on college campuses, and drinking. On the one hand, it's definitely helpful to know your limits when it comes to drinking, so that you can tell if something feels off and if you may have been drugged. Unfortunately, it is not unheard of. We know that people sometimes will slip something into somebody's drink to take advantage of them. We see cases of that, not too uncommonly. So certainly protect your drink is not the worst advice, and don't drink something that you don't know where it came from. But on the other hand, that protect your drink can slide into that type of idea can slide into victim blaming, and sometimes abusers will use the fact that the victim takes drugs or drinks. They will use that to smear the victim's character and to try to make them seem not worthy of sympathy, not a good victim. So it's important to try to be discerning and to be mindful when selecting who to associate with and choosing friend groups carefully that don't entertain these types of attitudes. That can be helpful for the survivors' emotional well-being and emotional safety. Now, how to make children safer. So in an ideal world, this wouldn't be necessary, but we have some in this reality, unfortunately, it happens. So we have some tools or some tips to help in these situations, depending on the age of the child. As soon as the child is old enough to memorize their home address and their phone number, their parents' phone number, teach them to how to call 911 and provide that to the police. Teach them who to call for help. This can, in addition to 911, this can include friends, and family members. Make sure that they know who to go to if they see the perpetrator at school. This can vary, but usually someone to go to can be a trusted teacher or an adult member, somebody in the staff at the school. Make sure the school knows not to give their name or their phone number to anyone. Self-explanatory, but in cases where the abuser may be a co-parent or they may be some kind of a family relationship, that can be an important consideration there. Now, preparing for an emergency. Obtain a cell phone that you keep charged on your person at all times if possible. If possible, keep chargers at work, chargers in the car, chargers at home, chargers in your bag that you carry around. Have emergency contacts stored, reprogrammed. Memorize important numbers in case you lose your cell phone. Do you know who to call? I think I'm one of the probably last generation that still have to memorize phone numbers. So with younger clients, that can be important to remind them, encourage them to know one or two numbers that they can call in case of an emergency if they don't have their cell phone with their contact list. And that can be, a friend, a family member, their local crisis center, or their advocate from their crisis center, or from Sally, or whatever it may be. The secret word or phrase. Sometimes people can previously arrange or talk to a friend and come up with a secret word to use as a signal in a crisis to let them know that they need help. Emotional safety. That's another key component during conversations with the survivor or safety planning. One can get a sense of the person's social safety net and their support network. So important information here includes, who else knows about the assault and who can you reach out to. Other people, we've talked about different ways that, providing accompaniment, or just helping them feel that somebody else is there as a witness or to call for help. Other people can be very important for survivor safety, and they can provide huge emotional support. Another thing, in addition to the immediate social circle or safety net, we can also refer them to their local crisis center, where they may have access to counseling services or other programs to help manage the effects of trauma. So this is not my specialty and not our specialty, but I know that crisis centers can help people work with somatic practices to help maintain a relationship with their body that works for them and to help heal in these situations. I have a question, actually. So are we running low on time, Steph, if you can hear me, if you're around?
Yeah, we're scheduled till 12, so
Okay.
you have about 20 minutes left.
Okay. So cyber stalking and technology abuse. For the next few slides, I'm going to focus on tips and questions that we use when discussing safety planning with survivors, and having to do with the use of internet and their connected devices. So first of all, what is stalking? In Maryland, stalking is a crime. It's a persistent and malicious pattern of approaching someone to make that person feel afraid that someone else that they or someone else will suffer serious injury, assault, rape or sexual offense, false imprisonment or death, or that the stalker intends to cause, they know or they could know that this conduct, will cause serious emotional distress to another person. And the graphic below, you can see some numbers about the prevalence. It's, as you see, very common. There, and cyber stalking. Unwanted advances or threatening behavior directed towards someone using the internet or other forms of online communications. And how severe is it? 21%, according to this source, of women ages 18 to 29 report being sexually harassed online. 53% say that someone has sent them explicit images without their consent. So extremely common. That might that sounds about at least that much from my casual experience. So stalking on social media. What does that look like? So this is something that doesn't always necessarily have to do with immediate physical safety, but I always want to bring it up in every case with every survivor, even if they don't have any concerns about safety. The area of internet use and devices, that can be their weak flank where they can accidentally put themselves at risk. So talking on social media, what does that look like? Following or friending someone to track their statuses or their activity. Keeping track of GPS check-ins. This is different apps and different services will share. They will share by default someone's location and information. So that's one area of potential risk. Sending harassing or threatening messages, making fake profiles to track someone. So we'll talk about not being very careful who you accept to connect with online. Posting anonymous abuse, posting false or defamatory information, posting nude images or other sexual content. So assessing risk and safety. First, does the perpetrator know the survivor's phone number or their email address? And again, these are not questions that I will explicitly always ask, because this is after I've had an hour-long phone interview with them about their case. I already know the answer to this. This is more a question for us to know and to keep in mind as we talk about this. So if they know their phone number or email, maybe the next question is, have they had any contact from the perpetrator recently or since the abuse? And I typically will also know the answer to that one after this interview. But then the question that follows: have you blocked them, or what can they do about that? Does the perpetrator know any of their passwords? Clearly, that can put someone at risk of having their accounts hijacked and the perpetrator having access to lots of personal and personal information. Do they have social media accounts? Most people do, and that can expose them to a series of risks, like I mentioned, their location being disclosed, and there are other things like their activities or their who they spend time with, or things like that. Do they share social media accounts with the perpetrator? Sometimes people do, and it's rare, but it can happen. And so where they log in from, that can sometimes reveal information to the abuser. are they friends on Facebook or connected? Do they follow one another on whatever service it might be? Um, that can certainly affect what the survivor's options would be or things to do. Is anyone in their social network friends with the perpetrator, or do they follow each other? So it's also important to consider not only does the survivor themselves have a direct connection on social media, but do their friends have a connection to the perpetrator? Um, Facebook, for example, will allow one of the levels of privacy is that friends of friends can see uh, someone's activity. Uh, so that's why that is important to know, so that they can take appropriate action if they feel that they would like to restrict access to that information. Uh, I mentioned this earlier, but has the perpetrator or their friends contacted the survivor since the assault? Um, have they posted? Has the perpetrator or their friends posted anything about the survivor online? And is that what was it? And is that still online? Sometimes we've used that as um, evidence when that's available. And the answer to all of these questions will, um, affect what types of suggestions and what types of options there may be for someone to think that they can do to make themselves feel safer, like reviewing their privacy settings and making things private and adjusting things to make their information more secure. Um, Even if a survivor feels perfectly safe in their situation, um, I always want to ask some questions to find out how they're using different online services and make sure that they're being savvy about their privacy settings, because they may be perfectly safe right now and they may be accidentally revealing to their perpetrator a lot of information about themselves. Um, so safety when using social networking sites or different apps. So here's some general safety tips when using the internet. Don't share information about your home, your work, your school, childcare, preferred shopping venues, social plans, methods of transportation, or any aspect of location and habits. Um, don't accept requests to connect with someone you don't recognize. Block the perpetrator or abuser on all shared social media platforms. Block friends, family, or others who might sympathize with the perpetrator. That is something that, depending on the type of relationship with the perpetrator, um, it may not be enough to block them, because someone else might be able to feed them information, grab screenshots of the survivor's activity and filter or like share that with the abuser. So any way that they can get information um, is potentially a way that the survivor might expose things that they wouldn't want to. Consider removing their profile, their picture from profiles, or using a nondescript image instead. Again, to anonymize themselves and go more, be more discreet in how they're using things. And review privacy and security settings for every profile. Taking time to review how the profile appears to you, to themselves, and to their friends and to the public. Uh, Assume any information online is permanently accessible by everyone. That's kind of what I mean earlier by friends in common sharing information. If it is out there, if it is online, somebody could take a screenshot and share it. It could somehow be accessible. The abuser could create a new account, send a new request, and um, gain access to the information that is online. Um, so that's that that's why that is a concern. And one thing I want to highlight, you can see the different icons of different apps or different services along the top. I always make it a point with clients under a certain age, probably like 35-ish at this point, to talk about Snapchat. Snapchat is very popular with younger people, and by default, there's the exact location, pretty much exact location with anyone that somebody is connected with as friends. But that can be changed in privacy settings. They make it hard. All these apps, they don't make it easy to be in control of your privacy settings, because the more you share, the more engaged their users are. So they have an incentive to keep people sharing as much as possible, but that can be changed. Another app that I haven't used personally, but Be Real also shares exact location with every post. So that's also an important safety consideration. So I ask people what they use and how they're using it, and if they're connected with someone. So there's some suggestions specifically for Twitter. I don't use Twitter, but they're here on the side. Should you be interested? Don't use the untrusted third-party apps. Of course, create a strong password. Login verification. People can steal passwords relatively easily, so login verification is always a good idea. And URLs can be shared through Twitter that can be used to lead you to some website where phishing, where people can steal passwords, get you to disclose your password and share it with them inadvertently. Facebook. There's lots of fake accounts and lots of harassment going on Facebook. So there's dangers on all of these platforms. Snapchat and Instagram. Safety tips: deleting identifying information from pictures, not using real information when signing up, and block. The block button is very useful. In the workplace, 1 in 3 women has been sexually harassed, 25% via text or email. So it's happening everywhere. Safety tips when using technology and the internet. Periodically change passwords. Use private browsing. This is when using a shared device. It can be at work or in the home when somebody's sharing a device with an abuser. This can make it so that they will not know what they're looking at online. Delete any old accounts through which somebody could gain access to things. Set boundaries with family and friends about tagging. This is another big one that I always discuss with clients. If like I mentioned, there's the friends of friends and the networks in common with an abuser. Another thing or another way that can affect someone is if someone else that they're close with takes a picture, takes a selfie together and uploads it to their account. If the abuser knows where to look, if the abuser knows who their victim's best friend or their parent or their cousin, who they are, and they're tracking this other person's social media activity, that can reveal to an abuser where the survivor is and where to go find them and where to go harass them. So depending on the situation, someone may need to try to not appear in group in these photos, or ask the other person not to upload, or at least not to upload immediately, not to tag the location, or to ask that you can't see anything in the background of the photo that could identify the location. All of these things a survivor may want to avoid being in these situations, or to have the conversation with, if that's safe to do so, with their with their social circle. Conserving safety and privacy with friends and family, that's more or less what I just said. Do not open suspicious messages or emails. Like I mentioned earlier, people can get sent links to fake websites asking for logging information, and accidentally they can end up sharing passwords with an abusers, or accidentally downloading spyware. Keep track of unwanted calls, text messages, and voicemails from the perpetrator. This can be useful for reporting ongoing harassment to police, and for legal action going forward. Now, spyware. Unfortunately, it is more common and more accessible now. People can afford to hire to buy spyware technology from as little as $40. So the low cost and the anonymity of the internet can make it so that people are more likely to cyber stalk beyond just looking at someone's social media activity. If somebody has spyware installed on their device, and that's software that is sharing information about location and activity to someone else, these are some signs that a device is being tampered with. And this can be if someone has been made to accidentally tricked into downloading something, or if a abuser has access to their phone and can or the computer, and they can download the program on their device. You may see a battery drain faster than usual, and background noises. The device randomly starts up or shuts down. There's weird messages or a lot more data usage. This doesn't mean necessarily that there's spyware, but it can be clues that the phone may be more active than what it appears to be, or a computer. Active in sharing information where it shouldn't be. One last thing I want to touch on regarding privacy and safety is explanations of benefits. That these are the letters that get mailed from insurance companies to the account holder of a health insurance policy. So with in the case where a survivor gets their health insurance through their abuser, these letters can reveal information to their abuser that could compromise the survivor's safety. So the state of Maryland has a request for confidential communications. It's a form that a survivor can fill out to ask that their information not be sent to their abuser after a medical visit or appointment. And the link is on the slide on the screen for that. I have some more slides or some more details on this on the next slide as well. But I think the most important point is that they may need to file again if they change insurance companies. I mean, if they're still being insured under their abuser and they change insurance company, and they have this ongoing relationship with an abuser, and they want to not have their information hit with the abuser continuously, they would have to file that form again for the new insurance company. And yeah, of course, if they don't do it, the information will be shared with anyone. The information will continue to be shared with the account, the main policy holder, and until it is approved, it will continue to be sent to the main policy holder. So yeah, that's all I have time for. I'm almost right up against the 12 o'clock, but I just want to mention the final 3 tips here, additional tips at the bottom. We can suggest that a client or survivor take notes, if that would be helpful for them, or we can send them notes that we take afterwards and review a final plan together. We can email them or mail them a list of, we have a list of tips and tricks. We can send maybe emergency contacts, and and resources or notes that we come up with together. So yeah, basically following up and providing the information in written form. Um, that's that. Thank you for your time. My information is up on the screen. That's my email address. If anybody needs to reach me to follow up or anything. And yeah, thank you. Have a nice rest of your day. Bye.
Great. Thank you so much, Juan Luis. Safety planning is so important and so detail oriented. So we spend a lot of time here to give you a lot of tools for that advocate toolbox. So Juan Luis, thank you for presenting that. I have put the link for the evaluation in the chat. I am getting some feedback that it can't be reached. We will also put that link in your email. So I just checked it and it was fine, but sometimes these links are a little finicky. So thanks for being patient with us. I also, as a little treat, you heard Stephanie talk about the clip from My Cousin Vinny, the expert witness clip. So I did put a clip of that, a YouTube clip of that in the chat. So that's something that you can enjoy on this Friday afternoon. I will say, if you haven't seen the movie, it is a spoiler alert. So if you want to watch the whole movie, don't watch this little clip. But if you want to watch it again or want to learn a little bit more about how Hollywood portrays expert witnesses, you can do that with that clip. I will say this is like a non-trigger warning. It's not about sexual assault. So feel free to enjoy that. If you have any questions for Juan Luis or Stephanie, their emails are available. And I will, I'm going to end our session. Have a great Friday afternoon. We crammed a lot of information into this week. So take care of yourself this weekend, and Alyssa will be back with you on Monday. Thank you. Have a great weekend.